Okay, I guess we should start. Hello, everyone. My name is Anna Wyrzykowska, and I'm an AIJA president. Welcome to the AIJA webinar on Interpol. What has it achieved and what does its future look like from a human rights perspective, which is organized by our Commercial Fraud Commission and Human Rights Committee. But before we start with our program, let me tell you a little bit about our association. Our association is the only global association of young lawyers, so lawyers below 45 years old. We are existing already for 60 years. Actually, this year is our 60th anniversary. And we are based in Brussels. We create a global network of lawyers to cooperate professionally, but also share knowledge and know-how, obviously aiming to develop professionally. Next slide, please. We are present in almost 90 countries, and we currently have approximately 4,000 individual members and supporters. Although we associate lawyers, young lawyers below 45, yet we are quite proud that 65% of our members is in leadership positions in their law firms. We have 50 collective bar association members and approximately 700 law firms of all sizes who are represented within AIJA. What we are particularly proud of is our number proving how diversified we are. Approximately 40% of AIJA members are women. We are associated, and as lawyers, obviously, we specialize in certain areas of practice. That's why we have 21 commissions representing certain areas that we want to learn about, that we want to share experience, and that are grouping our members, just like the Commercial Fraud Commission, which is represented during this webinar. So everyone can find something for themselves, depending on their practice. Other than that, we can, as members, engage ourselves with certain initiatives like AIJA Women Network, like Spotlight AIJA, which is devoted to certain practical things related with our work, with our profession. We also have our sustainability officer proposing sustainability initiatives. Usually those are online. And obviously we have as well, also represented during this webinar, the Human Rights Committee, who is making sure that we are all aware and up to date with all human rights issues around the globe to support them, also through fundraising initiatives, but also through organizing a number of events, also webinars. We have also appointed, only last year, the Legal Tech Board, which is working on making our members more familiar with the legal tech tools and new programs that are helping to perform our work and in general in our profession. But most of all, we organize events, in-person events and online events like this one. We will kick off next month with the second semester of the AIJA Academy. And we are working on preparing a quite nice lineup of series of other webinars for you. Other than that, we of course meet in person. Our flagship events this year is a half-year conference in Gothenburg, and of course our annual congress this year in Singapore. We also have, and we also organize, actually our commissions organize a series of seminars, again, either online or in person. And you see the current planning for the next semester until August this year. You can also find it on our webpage, aija.org. Those are AIJA contacts. So other than me, you have immediate past president François Barret, you have first vice president Moritz Maurer, and our association Victoria Kelly. So if you want to join us, please don't be a stranger. Send us an email, either of us or the general email of AIJA. Thank you so much. Charlotte?
Great, thank you very much, Anna. And thank you everyone for joining. It's great to see so many AIJA members and non-members joining this session. So thank you very much. Just to let everybody know, you'll have seen that we are recording this session and therefore questions and answers will be recorded as well. So you have been warned, please do not swear. Now, we're delighted to be joined by Russell Martha, the former General Counsel and Director of Legal Affairs of Interpol between 2004 to 2008. In addition to his role at Interpol, he's had a distinguished international career, including as former General Counsel and Director of Legal Affairs of the International Fund for Agricultural Development, the Minister of Justice of the Netherlands Antilles, and Minister Plenipotentiary in the Netherlands Permanent Representation to the European Union. He's also worked as counsellor in the legal department of the International Monetary Fund in DC, and prior to this as a legal advisor to the Central Bank of the Netherlands Antilles. He's published several books and journals on public international law, including the leading Interpol textbook, go and buy that one afterwards, The Legal Foundations of Interpol, published in 2010, and presently is a partner at Lindeberg Law, specialising in public international law, including, like the rest of our panel here, who will be introduced later, challenging the publication of red notices issued by Interpol, extradition, sanctions and export controls, and the settlement of treaty-based disputes. And we're very, very grateful to him for agreeing to speak to us today. Now, my first question to Russell, really, and apologies to the seasoned practitioners who I've seen already joining this on here, but given that some individuals on this webinar will not know much about the work of Interpol, we'd be grateful, Russell, if you could give us a short introduction as to the origins and governance structure and functions of Interpol. Oh, you're on mute there, Russell, sorry.
Good afternoon, everybody, and thank you for the invitation. Interpol was created in 1923, and it's basically an international organization, just like any other international organization, except that from its beginning, it has been set up different than organizations that have been created through diplomatic processes. It is an operational-oriented organization where police officers came together to devise the best possible ways for them to cooperate across borders. Interpol went through different processes, culminated in 1956 when the current constitution of Interpol was created, which culminated a period of frustration with what happened to Interpol during the Second World War, when it was basically kidnapped by the Nazis because of a design flaw that existed in the original constitution. And this has been removed on paper in the 1956 constitution. Nowadays, by design, no individual country can have a veto power in Interpol. No individual country can have a decisive voice in matters of Interpol. And Interpol has ensured that its international secretariat is actually an international secretariat in the sense that the civil servants are international civil servants. And unlike in the past, they are not just servants from a particular member state. Interpol is financed by its member states. Its budget is relatively small. And one of the consequences of that is that Interpol's staff is for almost 60% seconded staff. And that is a problem. We can talk about it later. Sure. But it affects the international status of the Secretariat, which on paper is properly designed. But in practice, of course, if 60% of your staff is seconded staff, you will see that that will have impact. And especially if you consider that of those 60%, the great majority of seconded staff comes from the United States and other rich countries. And that has also consequences in practice. Sure. Interpol's governance is, again, structured like any other international organization. You have a General Assembly, which is the supreme policy body. You have an executive committee, which is the body that supervises the work of the Secretariat and execute the decision of the General Assembly. In 1984, Interpol was confronted with the problem of data processing in France and was required to establish the Commission for the Control of Interpol's Files. And that was based on a bilateral agreement between Interpol and France. And that remained so until 2009, when in the current constitution, the Commission was integrated and has become an organ of the organization. A very distinctive feature of Interpol is the National Central Bureaus. They have a double hat. On the one hand, they are national police bodies, but they perform an international function in the Constitution of Interpol and the rules of Interpol. That also, which from an operational point of view, it's a good idea, but it has its drawbacks. And we will see that when we discuss the issues of processing of data and request of red notices. All by all, I think throughout this discussion, we should keep in mind that Interpol is an international organization. That means that it has a mission, and that this mission is its primary goal, and that's to help police combat crime. And that, of course, as any public body, it affects the life of natural persons, and that consequently it has to observe certain standards of human rights, and that is also recognized in Article 2 of the Constitution. Article 3 of the Constitution, which is the one that most people refer to, deals with what Interpol should not get involved in. And Interpol is not the only international organization that has this. The IMF has a similar clause that's comparable, the World Bank also. It means that essentially the organization has to observe political and religious and military neutrality. And to do that, the Constitution prohibits the organization from engaging in any activity that has to do with that. Over the years, that particular clause has posed a lot of problems for the organization, but the organization has developed a doctrine. It is the predominance doctrine. That means that normally something that is an ordinary crime that is not considered political, but it may have elements that is political or religious. And if those elements are dominant in this particular case, that will mean that the organization cannot get involved in that situation. And that may involve not issuing a red notice, not processing the data, not allowing its mechanism to be used. I would like to finalize on the issue of mechanisms for member states to cooperate. Over the years, Interpol has evolved a network for exchanging information between member states. It created databases, and especially in the first decade of this century, it went online and made it possible for police anywhere in the world to access its databases on a 24/7 basis. And that has rendered Interpol very, very effective. And that is the reason also why Interpol has become more at the forefront, and we experience the consequences of Interpol's interventions more than before. And it's not surprising that therefore in the last 15 years, this practice area of Interpol lawyers has evolved, simply because Interpol has become much more effective in what it does. But the design that was put in 1923 has remained the same in terms of how police cooperate with each other, focus on operational efficiency. And that's why I think it makes Interpol one of the most interesting organizations from the point of view of human rights.
Sure. And thank you for that. And just as your role when you were general counsel, who was it that within, you mentioned some of the structures there, obviously the CCF, the Commission for Control of Interpol's Files, the General Secretariat and the Executive Committee. What was your role? Who were you advising within the concept of Interpol?
No, again, just like in any international organizations, the role of the legal department is you are the lawyer of the organization. That means that you advise in your day-to-day, you advise the General Secretariat, so the executive chief of the organization, in this case, the Secretary General. But also you are also the lawyer for the executive board. You are the lawyer of the General Assembly. And with regard to the commission, you are the lawyer representing the General Secretariat. When its actions are challenged by private parties, you have to represent the General Secretariat and respond to the challenges.
Sure.
So basically, you have a double head in a sense that you are subservient to the Secretary General, but your position requires you to take distance and even advise against the Secretary General if that is the case in any of the other organs, which is the General Assembly or the Executive Committee. You have also external representation when the organization is challenged, or setting up cooperation with other organizations or national governments. That all of that is the responsibility of the legal department, hence of the General Counsel.
Sure. And you mentioned that obviously some of the challenges. You were General Counsel during between 2004 and 2008. So when you joined Interpol, what were the perceived challenges then compared to what the challenges are now of Interpol? You know, are they the same, or do you think that they've progressed or differed in some way?
Okay, I have to distinguish between the challenges that the organization perceived for itself when I was hired and the ones that I have detected when I arrived. The organization at that time had a big concern about its status as an international organization, because Europol has just been created, and it was created by a formal international convention at that time, as a formal treaty, and Interpol's constitution has never been considered a formal treaty. It's a very informal international agreement. And there was a lot of concern that that would affect Interpol's credibility when people start to compare Europol and Interpol. So one of the tasks that they imposed on me was to come up with a process to reconstitute Interpol on the basis of a treaty. I advised against that. If you read my book that you refer to, is basically an outside opinion that I wrote to explain why that was absolutely unnecessary, and that the Interpol constitution, as the way it was, fulfilled all the functions it needed, and there was no reason for it to spend time on creating a new treaty. I'm glad that that advice was heeded. But in that process, of course, one of the first things that I noticed was how much more red notices were issued, how much more databases were created. and how much more the internet was facilitating Interpol to become a more effective organization. So at the same time, you had in the European Court of Human Rights, the issue of that immunity of international organizations have to be refused if the organization cannot provide an alternative remedy for individuals. That was the Wade and Kennedy decision. At the same time was also that the International Law Commission was preparing the draft articles on responsibility of international organizations. And the combination of those two processes for me posed the real risk for the organization, because the legal framework in which the organization was operating was changing and therefore opening up the organization to challenges by individuals. And one of the main things, my concern was to avoid that, like what happened to the Western European Union, that at some point a member state's court will say, we do not recognize Interpol's immunity and we will subject it to domestic legislation. And that, of course, would render the organization ineffective. And for that reason, I focused very much on boosting up the legal processes of the Commission so that it can respond more adequately and avoid the problem of risk of its immunity. And that culminated in 2009 with a revised treaty between Interpol and France for its immunity in France. And in that treaty, you will see that in Article 24, there is a special catch-all provision now saying that if there is no other provision for protecting individuals against Interpol, Interpol subjects automatically to the jurisdiction of the Permanent Court of Arbitration to settle dispute between Interpol and private parties. So to answer your question, the perceived risks that they had was whether it was a treaty or not. I didn't consider it to be a risk. I focused on protecting the organization's immunity. And if you look at what happened since then with the increase of challenging of Interpol, I think that was a wise decision. Interpol's main challenges now is that it has to evolve, if you ask me, evolve the system that has been designed for the Commission to deal with challenges, that this has to be converted into a proper judicial process. The current system is inherently incoherent, and we will discuss that. And this incoherence is the reason why there is this perception that Interpol's instruments are being misused or abused by member states. I think that's not the case. I think that it is an inadequacy of the functioning of the General Secretariat that is causing that. And this is this design flaw that needs to be addressed. And if it is not addressed, at one point, it will cause Interpol its immunity.
Sure. And so jumping around a bit, do you think that Interpol is sufficiently held accountable for its actions and that there are sufficient mechanisms to challenge those decisions made by Interpol and seek remedies in relation to the processing of data?
My answer is that the fundamentals for proper protections are there largely, but they are inadequate. Let me try to explain one discussion that I had for a long time when I was there. Interpol assumes that the data processed in its databases, that the information is from the country that provides that information. So the national sovereignty over the information. I say that's true, but whose databases is it? The databases are Interpol, and who allows member states access to that database? That's Interpol's rules. That means even though that the information in the databases comes from member states, Interpol is the one who makes it, who processes it and makes it accessible. And that brings responsibility with it. A consequence of this discussion is that when you challenge Interpol, a red notice, for instance, you don't see the General Secretariat's response to your challenge.
Mm.
When you look at the decision of the Commission, the Commission never says what the General Secretariat said about its decision to grant the red notice request, yes or no. You will see what the member state has said. And you don't see everything either. So that is not an adequate legal process. You are litigating against the wrong party. It's not the member state. You're supposed to be litigating against the General Secretariat. You see what the member state says, but you don't see what the General Secretariat says. That's incoherent. That's a fault in the thinking that still comes from this theory that the source of the data is a sovereign. But the data wouldn't have been there if the General Secretariat had not allowed it to be there. Mm. And therefore, the decision to allow it to be there, that's a decision that you challenge. And if that is not improved, these decisions that the Commission is issuing, if ever they will be reviewed from the point of view of the right to a fair and effective remedy, they will be deemed to be inadequate, and that can pose a challenge for maintaining Interpol's immunity.
Mm-hmm. And so following on from that, I mean, there's a lot of criticism of Interpol being sort of open to abuse by autocratic nations, and it's not successfully sort of able to prevent Interpol from undertaking activities of a political, military, and racial character, as you mentioned in your preamble. You know, do you think that Interpol is able to or willing to prevent abuse by these sorts of regimes?
Yes, by design it is, and I take issue with the assertion that any country can abuse the system, because it's not a member state that is issuing the red notice or processing the data. Mm-hmm. It's the General Secretariat. But if we go back to the issue of secondment that I have mentioned, if 60% of your staff is seconded, paid for by a member state, and let's say 16% from the United States, and the General Counsel is from the United States, and the executive, the Chief Executive Police Department is from the United States or from a friendly state, it's very difficult for the General Secretariat to refuse a red notice request from the United States. It's interesting enough, when we talk about abuse, nobody mentioned red notices issued by the United States. We talk about China, we talk about Russia or Turkey. These are the easy red notices for the General Secretariat to kick out. Mm-hmm. If a request for red notice comes from the United States, the General Counsel will be put on an incredible pressure if he wants to say no.
Sure.
And those cases never gets into the newspaper. So I always say, when they say catch the thief and you point in one direction, I'll say, look at the one who was saying catch a thief. Last year, we went through an experience with one red notice issued at the request of the United States, without an arrest warrant. There was not even an underlying arrest warrant. And when we pointed that out, instead that it was properly processed, the General Secretariat convinced the United States to withdraw its request, so it cannot be held accountable. So what I'm saying is that you have to look at the composition of the General Secretariat if you want to resolve this problem. Mm. It means that the organization's budget has to be increased. It means that the organization should pay for all its staff, like all other international organizations and not be dependent on member states that are willing to send staff and pay for them. Because then you become dependent from the member states that make the payment. To me, that is against the design of Article 30 of the Constitution that says that the staff is international and that says that the loyalty of the staff is to the organization and not to any other country. So I have a different view about the abuse question than what is normally held. I don't consider Russia to be abusive. I don't consider Iran to be abusive. I don't consider China to be abusive. In my practice, I have never had a problem challenging those red notices. The problems that we have had was the red notices issued by the United States.
I think a lot of people on this call will be very interested about that. And obviously, we'll take some questions later on about that. But so, you know, following that, if your views are that sort of the United States are actually the problem, what are your views then as to the seemingly politicized nature of some of Interpol's sort of presidential appointments more recently, and Interpol's financing through private and state entities? I mean, do you think that has a bearing on the way in which Interpol operates? It seems that you do think that from the United States, but are they simply ceremonial positions or justified fundraising?
If you had asked me this question before 2016, I would have told you that it doesn't matter how and who is the president of Interpol. But in 2016, we saw that China effectively removed the president of Interpol, and we still don't even know where he is. And so the fact that a member country can do that means that the governance structure of Interpol is subject to intimidation. But it has always been the case, and it's the case in all international organizations, that the president of the organization, the members of the executive committees, they are elected by the members. So that is inherently political. But if you mean political in the sense going in a certain direction, I still have to see that actually happening. It may not always look pretty for Interpol. And I will tell you that in 2008, I went to the painful exercise to see a president have to step down and be indicted in its member country. We have seen in 2016 what happened to the president from China. And now already we know that the current president of Interpol, if he travels to the United Kingdom, will be arrested because of a case that has been started again. So indeed, it doesn't look good that now that Interpol has become so a known factor in the world, that its presidents are the ones that now are each time getting into trouble. I think that hopefully that going forward, Interpol goes back to the old tradition in international organizations to find what we call neutral heads and elect people from very small countries that are neutral and that are less exposed to political issues, and avoid therefore that its organization gets into this limelight, which it's not normal for an organization over the period of 15 years, 3 of its presidents to get into trouble the way we are seeing now.
Sure. What I'm loath to stop this discussion because I think it's really interesting to get. And I'm sure that the questions at the end will elucidate more on your answers. But we've now got the panel to discuss. And Nicola, I understand you're going to introduce, and thank you very much, Russell, for your answers. You're going to introduce the rest of the panel.
Thank you very much, Charlotte, and thank you also to you, Mr. Marta, for these insightful and frank answers on Interpol's activity. On behalf of the Commercial Fraud Commission, I have the pleasure to introduce you the panel of this afternoon. This panel will address in particular problematics in relation with Interpol red notices. These are the most scary tools used by Interpol with a worldwide reach and the purpose to bring people to justice. But let's leave this kind of appreciation for the panelists. For now, I'm going to introduce our panelists. As a first comment, I have to say that we are honored to host today panelists coming from law firms with a strong reputation in white-collar crime, law firms which deal notably with Interpol-related issues. Further, all the panelists are or will soon become members of the AIJA Commercial Fraud Commission, and as you cannot claim to fight among the best without being such member. The panelists, Charlotte Treguna, you have heard her already, is moderating the panel. She's a senior associate at the law firm Peters & Peters based in London. Charlotte has a solid reputation in white-collar crime. She has expertise in domestic and international corporate crimes disputes and investigations, including fraud, corruption, money laundering matters, but also international sanctions, mutual assistance in criminal matters, as well as Interpol cases. And the AIJA Commercial Fraud is, of course, lucky to have her as a very active and resourceful officer. Now, our speakers, Julie Zoria. Julie is a partner at the law firm Navacel based in Paris. She has a long experience in financial crime matters, representing sovereign states, financial institutions, corporate, and in senior executive in the fields of fraud, corruption, money laundering, and international sanctions. She also leads the firm practice on extradition and Interpol issues. We are also happy to have Diana Zugler. Diana works in the litigation and investigation group of the firm Allen Novery based in London. She's specialized in all areas of business crime defense. Her clients praise her for her experience in preparing their defense from the private investigation until the criminal or the civil trial. And she also has a strong experience in extradition and Interpol matters. Another fierceful business crime lawyer that we are honored to receive, Katerina Shapran. Katerina is a managing associate at the law firm Artzinger based in Kiev, Ukraine. She specializes notably in white-collar crime matters, on anti-corruption compliance and business ethics practices. She also represents clients in the courts of mutual legal assistance in criminal matters, as well as before Interpol and Europol on issues of wanted notice. And last but not least, Andreas Pfister. He worked at the law firm Wessing & Partner based in Düsseldorf, Germany, which is focused on white-collar crime representation. Andreas advises and represents both individual and companies in all areas of corporate criminal law, criminal tax law, and antitrust law. A main focus of his work is the support of complex international proceedings, as well as the criminal law support of civil law matters, in particular the support of civil proceedings with criminal justification of claims. The presentations are now done. It's time for our distinguished panel to debate. Charlotte, the floor is yours.
Okay, back to me. Just in terms of red notices and sort of practical consequences in the life of a person who's subject to a notice, Diana, what can you tell from your practice that what are the practical consequences on individuals?
Thank you very much, Charlotte. And thank you, Charlotte and Nicola, for hosting. Do let me know if you can't hear me. I'm set in the middle of the Indian Ocean and there is a tropical storm raging outside behind me. So any background distraction, I apologize. So back to topic. Well, it might not come as a surprise that having a red notice out in someone's name can indeed have very wide-ranging and extremely serious consequences and impact that person's ability to conduct both their personal and business affairs. Now, these difficulties would typically primarily manifest because of that person's ability to travel being severely restricted or completely prohibited by reason of the red notice being in place. Should they travel to a country that's part of the red notice system, because it basically is everywhere, whether that be through a land border or entering by sea, car, plane, it doesn't matter. At best, the country into which they enter is going to let the requesting state, so the state that issued the red notice, know that that person is now in a particular country's territory, which puts that person at severe risk of an extradition request being issued. In addition, some countries would actually arrest that person solely on the basis of the red notice being in existence. Now, the best case scenario, thinking about this practically, would be for your client to be detained at an airport, for example, for a number of hours and then being released. But in any event, it's great inconvenience, and it doesn't matter if that travel would take place for the purpose of business, leisure, family, or medical treatment. The same severe consequences would apply with no exception. So we have seen, and I'm sure that's true across the whole of the panel here, we have seen many clients being prevented from visiting ailing family members, receiving crucial medical treatment, being able to conduct their business affairs. So that's really the primary issue. You also won't be surprised to hear that there's obviously reputational damage associated with that. If you can't conduct a business meeting, you have to explain why you can't be present. If your client is arrested and that arrest is publicized, then there may be adverse media. As a result of adverse media, that could mean that your client's arrest or detention on the basis of the red notice will show up on news alerts. That may mean that if your client has a profile with one of these compliance databases, for example, if they are a PEP or a former PEP, then the fact of their arrest and the existence of the red notice would filter in onto their profiles. That could in turn impact their ability to have or maintain bank accounts, banking relationships, as part of financial institutions' drive to de-risk risky customers. And unfortunately, someone with a red notice out against them could be deemed to be risky just on that simple basis. And just to lastly mention something quite specific, for example, the US immigration authorities have been known and reported to arrest and detain people in detention centers. If you are an illegal migrant with a red notice out against you, then ICE may unfortunately use that to keep you detained for an extended period of time and then deport you out of the US.
Sure. And so it sounds horrendous. So Katerina, how can you get a red notice removed? What are the steps in doing that?
Thank you, Charlotte. Thank you, everybody, for joining our webinar. Please be informed that according to European Interpol rules and procedure, there is official procedure for delisting a person from Interpol database. The person or attorney on his or her behalf may apply to the Commission for the Control of Interpol files with a well-grounded application to have information about him or her deleted from the Interpol database. This is a special form of such application of the official website of the Interpol, where everyone can find it and download it. So what person should do? The person has to complete this form, describe a brief statements of facts concerning the complaint. In particular, the person has to state which notice were issued against him or her and why he disagrees with that. Because as you know, there are few notices, for example, blue notice, red notice. We will not tell about others. Yellow, black, it's not our seminar yet. But in case of blue or red, the person should note that she have information about such issue. Then the person also need to add a list of important appendixes to this application that prove the described facts. And then the person or the attorney on his or her behalf has to sign this application as sent to the Commission for the by post mail. You know, it's interesting that despite COVID-19, there is still a rule to send a hard copy of all these documents by post rather than email. As a positive point, that further correspondence maybe via mail. In many cases, Commission writes you on email and propose to continue a correspondence via email, but not post. I remember the time when we send in hard copies of all the documents. We're waiting a month for the replies, and it was really terrible. So thanks for it, for this maybe positive side of our corresponding. And the person can only apply to the National Bureau of Interpol. We send a ban to ask General Secretary to cancel the notice on appropriate grounds. And as you know, every country has its own rule for such national applying. Please not to forget about it. Maybe a little later I will tell about Ukraine. Thank you.
Thank you, Katerina. I also remember hard copy and I miss hard copy. Julie, what are your views on the actual delisting, let's call it delisting process itself? Is it compatible with fair trial guarantees, such as the right to be heard, the right to an independent and impartial tribunal? What are your thoughts on that?
Thank you. I think it's a good question, and the answer evolves over time depending on what will become of Interpol. The CCF in many cases has demonstrated its independence and decided the deletion of the red notice as challenged red notice. The process is regulated, the time limits are provided. Interpol has 9 months following the admissibility decision to decide on the deletion request. I have to say that this period can be, however, extended, but there are time limits. Argument can be formulated, and there is an existing form of adversarial process, as you are informed of the adversarial argument by the CCF. However, and as mentioned by Mr. Russell Marta, you don't have the information on the general secretariat position. You are not direct recipient of the communication from the ensuing states. The substance is transcribed by the national central bureaus or by the commission, but you are not direct recipient. And regarding the hearing, the access to the hearing is left to the discretion of the commission. So to conclude today, I would answer affirmatively to the that the delisting processing is compatible with the fair trial guarantees, but improvements could still be made, notably as mentioned by having access to the general secretariat position, for example.
Sure. And Andreas, do you have any thoughts on the same question?
Actually, many. No, I just have to recollect what already has been mentioned and what not. I think something we familiar with the matter tend to forget is that there are only 4 official languages in which you can actually deal with a request for delisting, and that's it's Arabic, English, French, and Spanish. And so normally you have the right to an interpreter, and also, of course, you should have the right to get translated the necessary documents. Here, for example, you don't have this. You have at your own cost to translate all that you think necessary for your request. But on the other hand, the process itself at Interpol is free.
Okay, and so in terms of your own success, obviously you're all defence practitioners, you've all had successes and disappointments. Katerina, perhaps you first. I mean, what kind of successes have you had? What have been the arguments that you have successfully deployed in order to remove red notices?
Thank you. We know that in Ukraine, the most notices are requested by National Investigative Authority. They're based on political persecution. Unfortunately, it's our reality, and the most notices were issued, unfortunately, on these political grounds. And of course, it's not an official information, but in many cases, I and also my colleagues, we found such traces. And from the prior successful experience, we canceled the red notice of a client a business partner of one politician. You know, the interesting point was that this political partner of our client, he had a dispute with another powerful businessman of Ukraine. And so our client just became a victim of the struggle. He didn't committed any illegal actions. He also won the commercial dispute. And despite of that, our investigative body issued a red notice against him. And the client was unfortunately catched in different foreign countries. So we have to save him. And we obtained a lot of procedural and factual circumstances, proving that our client was illegally added to Interpol database, that the notice was issued unfounded, illegally, and we spent, I think, a lot of times, many days to obtain this information from Facebook, from internet, from official documents, from court decision, and it's really a huge work. And I think it's a nice success for Ukraine to prove a political character of the case.
Absolutely. And Julie, have you had similar situations where there's sort of politicized red notices have been issued and you've successfully removed them?
Yeah, we have the same experience, and I think it's the political argument and the diversion of the commercial procedure is the main ground to challenge the red notice. But in terms of efficiency of the argument, experience has shown that procedural arguments related to the specific rules of Interpol should not be overlooked and could be very efficient, notably the provision specific to red notice or to the functioning of the procedure for processing data from Interpol rules named on the processing of data. And it's very efficient. It's technically, because you have to read all the rules in order to find the good provision, but it's in terms of efficiency and time, very efficient.
Sure. And Diana, how about you? I'm sure you've had some successes and disappointments. What have been your ones to call out on this call?
Well, let's stay with successes. That's happier ground to talk about. Again, political motivation. Had a set of clients who were caught up in what I can only describe as a religious disagreement between the state or sort of leading arms of various religions amongst two nation states, and by conducting business with one of the two states that the other states deemed to have been, involved with terrorists and proscribed organizations. The client themselves, although they didn't really do anything other than conduct legitimate business, were caught up in what was characterized as a serious money laundering and terrorist financing offense. But really, it was quite a subjective assessment of what or who amounts to a terrorist or a terrorist organization with which we disagreed. And it was a very protracted process, and the opposing state was very fierce in the arguments they brought forward. But luckily for the clients, the notice was deleted, and there actually was an old AL family member that the client could not visit due to the notice. So that was a sort of really nice personal touch for them to actually be able to go and see their mom, because they weren't able to do so for the best part of a decade.
This is what we're like as lawyers, just helping everyone out. So what about Andreas? What about you? Any unusual arguments that you've successfully managed to deploy to remove red notice?
Difficult. I could say what we currently have a problem is, so it's not a success story, but a ongoing story. And this is a client from Ukraine who claims that he has once been a pro-Russian activist in Ukraine. And now they say that he has committed several crimes at certain moments in time. And we have it very well documented that he was not in Ukraine at the time he shall have committed these crimes. But we cannot actually factualize his pro-Russian activist background.
Sure. And Russell mentioned that the sort of the process have improved over the last few years. Do you think, Julie, perhaps the delisting process has improved? You know, do you think why do you think that is?
Yes, of course. Of course. I have no, of course, but I have not identified any improvement regarding the Interpol delisting process as such. But with the COVID, and I think it was mentioned by Katarina, with the COVID, there are modification in the communication with the CCF, which now is through email and electronic contacts, and this avoids delays with mail exchanges, and so there is a certain gain of efficiency, but not in the delisting process as such.
Sure. And I'm just noticing the time, and obviously I do want to get some potentially some questions in. So sort of last question, and open to the four of you. I mean, does we were talking, Russell was talking earlier about mechanisms and whether there are sufficient mechanisms to challenge red notices. You know, does your jurisdiction offer any remedy to an Interpol red notice, so challenging it domestically? Do you think that should be something that should be imposed? Who wants to answer? Andreas?
I can say that we have one, and actually it's a question that our Liberal Party itself asked the German government in 2018, and so I can very thoroughly say, yes, we have one, even though it's not as strong as the German government has claimed.
Sure. Anyone else want to answer that question before I throw it open to the floor?
Charlotte, may I just make two observations?
Of course, absolutely, Russell. Please go ahead.
First, on the question of the focus on Article 3, which I think is, I understand why, but if you look at the rules, there are three general conditions for a red notice or any data to be processed: lawfulness, accuracy of data, and the political neutrality. On the point that Andreas was mentioning, that he cannot prove that the person was involved politically, but he has evidence that the person was not in Ukraine on the date of the occurrence. I think at that point, you should abandon the political argument and focus on the accuracy argument.
Totally agreed.
Because then, of course, if it is so evident that the person was not on that date in Ukraine to commit the crime, and the crime requires his presence, then there is no way that a summary of facts can satisfy the accuracy requirement of the rules. So that's one. On the last point, I wouldn't say that it is adequate. I think that there is an inherent danger in the way that the Commission assumes its role. The Commission says it doesn't evaluate evidence because it leaves that to the national authorities. But the evidence that you afford to the Commission is not to litigate the guilt or innocence of the individual. You present evidence to the Commission so that the Commission can assess whether the red notice has been issued in accordance to Interpol's rules. And that requires evaluation of evidence. And the reluctance of the Commission to evaluate evidence renders the procedure very weak. It takes cases that are manifestly political or religious to actually win. And one of the areas where cases have been very difficult to win is, for instance, when commercial disputes are converted into a criminal case. And whereas the rules say that in that case, also the Interpol should not get involved, the Commission always finds a way not to rule in favor of that argument because it doesn't want to weigh the arguments. So there you see the reluctance of the Commission undermining the efficiency of the system.
Sure. Thank you so much for that. I mean, I noticed that it is 3 p.m. So I would thank you so much to all the panelists, and thank you, Russell, for your final comments. Does anybody have any questions before I hand over? Andreas has a question, but he is on the panel. So I think if anyone wants to.
Charlotte, hi, I have a question. Edward Grange from Corker Binning.
Great.
It's a question probably for the panel, but perhaps more aptly aimed at Russell. Ordinarily, representations to the CCF, we know, are summarized and sent back to the issuing or requesting NCB. And then the NCB are invited to provide their comments or response to those representations made by the applicant. Is there a hook upon which I can hang my submission to get hold of the response from the NCB? Because we all know that very often they will dig themselves into holes with the information they provide. Because the first you will see of it, in my experience, the content of the response is in the CCF's decision itself. So is there any ability within the rules or outside the rules in order to persuade the Commission to provide you with the response from the NCB to the applicant's representations?
If I may take the first bite at it, I think that the answer is in Article 2 of the Constitution, which includes the reference to the Universal Declaration of Human Rights, which includes the right to effective remedy. And if you want to effectively challenge an Interpol intervention, you should know what motivated the Interpol to say this is red notice, I can issue it. Now the rules provide in Article 84 for the requirement for legal opinion. We have tried to obtain that legal opinion. The Commission ruled that that legal opinion is an internal document of Interpol, and therefore you cannot get access to it. We have also argued that in order for a procedure to be fair, if the Commission is going to rely on what the requesting NCB is providing, then it should give us a chance to argue against the response. On that point, also the Commission has said no, it's not going to do that. So that again shows that the design flaws in the system, because it doesn't actually allow you to effectively address the reasons behind the red notice, and the Commission will be satisfied with an answer provided by the NCB or by the Commission, by the General Secretariat, without allowing that to be contradicted. And I don't think that will satisfy what we understand to be a contradictory procedure.
Great. So does anyone else have any thoughts on that before I hand across? Anyone else? Thank you, Ed, for that question. I hope it answered it.
Absolutely, thank you.
Great. Okay, well, look, thank you very much to Russell particularly, and to the rest of the panelists, and I'll hand over now to Clara to talk about our next sessions in the series.
Thank you very much, Charlotte. And on behalf of the Human Rights Committee, a huge thank you to all the speakers and our keynote speaker, Russell, and the Commission for the Commercial Fraud Commission for organizing these absolutely terrific session. Just to let you know that we will have 2 additional webinars that are foreseen for March and April in our series of webinars which deal with your day-to-day activity and human rights. So stay tuned. We will make some announcement in the next weeks. We will have the private client commission and also the IP and TMT commission that are organizing with us some very interesting webinars. So
look forward to our next announcement, and thank you again for these absolutely interesting discussions. Have a very nice day. Bye-bye.
Thanks, everyone.